Good afternoon, Spartans. Happy Thursday, February 15th. I hope you had a wonderful Valentine's Day and your cup filleth over with love and appreciation from those who hold nearest and dearest. Today we have our weekly check-in, last weekly check-in today for the week. Zoom is 140 to 225. You can still email me today or tomorrow. Remember though, tomorrow is an early release, so it's got to be done by noon. Today, we're talking about the discussion question that you should have responded to by today or before today. And then we have one Supreme Court case to talk about, and then a quick review of something called a compelling government interest. And then we're done here for the week. You're done with any sort of new information coming from me. This is the last video. You will start watching a video tomorrow, and you'll have to have that done by Tuesday next week. That is correct, Tuesday next week. So we'll end the video with explaining how to fire that up. So let's talk about that discussion question. Again, kind of gave you the background here of when our country was reorganized in the end of the 1787, ratified in 1789 when the Constitution was written. Ben Franklin gets asked the question, what do we have? And the answer is a republic if you can keep it. We should understand that the Constitution was written to protect the people from the government. The United States Constitution was protect the people and the states from the United States government. We were worried about, after the collapse of the Articles of Confederation, we were worried about a national government becoming too oppressive. We wanted to make sure the people and the states had power what was going on. So the Bill of Rights, the first 10 amendments are added to the Constitution. The 14th Amendment then applies the Constitution to the state governments as well, which is really kind of the premise here about the entire discussion regarding the Second Amendment, if we should have more gun laws or less gun laws, or somewhere in between. If the Constitution was meant to keep people safe from the government or allow people recourse, protection, some means to protect itself from the government, it's going to need to have weapons. It's going to need to have a militia. In the 21st century, we clearly have a problem with guns. So the question is it better to risk danger and even death in exchange for living free, or is it better to risk tyranny and oppression in exchange for the possibility of more safety? If we have more gun laws, will it make us any safer? If we have less gun laws, will it make us any less safe? If we give the government more say on what we can and cannot do with the arms we keep and bear, will they be able to be more tyrannical or oppressive? I don't know the answers to these questions. I mean, it's a hypothetical. I'm very interested in going through your thoughts on this, but this is not a question solely based on guns and gun control and gun rights. It's literally about every single topic. What about education? What about speech? What about healthcare? What about reproductive rights? What about who you marry? What about how you want to handle death? What if you're sick? Do you have the right to commit suicide? Do you have the right to assisted suicide, or should you have to go through some long, grueling, drawn out, painful, awful death? Anytime we allow the government to make a decision, we are giving up rights that we do not give back. So is it better to risk tyranny and oppression for the possibility of safety, or something better, or something more luxurious, or something that's more accommodating? I mean, literally, it's anything. Or do we run the risk of danger, inequality, death, hurt, poverty to be free? If you look at a lot of the main topics that are current events in the 21st century, right? Reproductive rights, speech, interpersonal relationships, who we date, who we love, who we marry, children we have, children we don't have, guns. These all became Supreme Court topics in the last 130, 120 years. These are all relatively new. A lot of these decisions were initially left up to the people, left up to the states. Doesn't mean it's right, doesn't mean it's wrong. But is it better for the people to make decisions for themselves, or is it better to allow the government to make decisions for the people? That's really the crux of the matter. If you give the government more power, they're not giving it back. If you keep the rights for yourselves and you continue to demand the rights to be kept for ourselves, then the government doesn't expand its power. And again, this gets back to Ben Franklin's statement, a republic if you can keep it. Real interested to see what you guys have in the discussion. Because it is it's a philosophical question and there is no one right or wrong answer. We talked about Miller versus the United States in the 1930s last week. All right. Again, just to review here, it says that in the Supreme Court case that the federal government has a right to regulate arms, which is interesting to me because again, the Constitution spells out that the states and the people are protected from the United States government. That's what the Second Amendment was for, to protect them against the US government. So I'm not quite sure where this reasoning comes from. And again, interpreting the Constitution comes down to 9 Supreme Court justices who have been appointed for a lifetime position on the United States Supreme Court. But Miller versus the United States, or US versus Miller, excuse me, also hints at private ownership, that people have a right to a gun. And this comes back from our country's founding. Like when we rebelled against the British, it wasn't the United States government buying weapons for people to use because the United States government didn't exist. We were still part of the United Kingdom. It was the colonists who had these weapons, and it was the colonists that used those weapons to fight against the British. These rights get expanded in recent years. District of Columbia versus Heller in 2008. There was a law that was passed in the District of Columbia, Washington, D.C. Washington, D.C. is not a state. It's not a part of a state. It's an independent district. It sits between Virginia and Maryland. We didn't want our national capital to be a part of any one state because we were worried about that state having advantages over the other states because they had the capital. So we made it our national capital its own little entity. So it's governed by federal law. The Congress has to decide what goes on there. For the most part, they do have a city council, but in the District of Columbia, the city council passed a law requiring that all guns be safely stored, be stored without ammunition in it, disassembled, and also required a lock on the trigger. It also banned the use of handguns or possession of handguns within the District of Columbia. This was challenged by a retired police officer, if I'm not mistaken, because he was denied a 1-year permit to possess a handgun, which was part of him, part of his daily doings as a police officer. What the Supreme Court decided in District of Columbia versus Heller is that this law exceeded constitutional authority. Justice Antonin Scalia, I believe, wrote the opinion for the Supreme Court. He said that citizens have the right to ordinary guns, not every gun, ordinary guns. He said there is limitations to what people could have, but that people have a right to ordinary guns, which is very much similar to what Miller said, or the Miller decision in the 1930s, that people have a right to a gun, that the government does get to regulate it. But the decision continues to make some changes here. Antonin Scalia said that guns are necessary, ordinary guns are necessary for defense, not for defense against government oppression or government tyranny, but for self-defense, for the defense of the home. So again, we go back to this question here. Is it better to risk danger and death in exchange for living free, or is it better to risk tyranny and oppression in exchange for the possibility of more safety? If we look at the Constitution of the United States, and again, the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. I understand Scalia's opinion here on defense. I understand Scalia's opinion here on the right to keep and bear arms. But where are we drawing any sort of conclusion, or where are we drawing a basis on which we can conclude, rather, that people's guns can be limited by the government? Where does that come from? Again, once we let the government make a decision on something, once we give the power to the government to make a choice, we don't get that decision back. It's theirs. It's the government's. Gone forever. So I don't know what the answer is there. The 2008 decision, District of Columbia versus Heller, was then transmitted to, because again, Washington, D.C. is now not a state. It's not a city. I mean, technically, it's its own independent district. A follow-up case, McDonald versus Chicago, applies the same concept to city governments by the 14th Amendment. People have a right to keep and bear arms for self-defense. The federal government can regulate it. State government can regulate it. City government can regulate it, but those regulations have to meet two criteria. One is a compelling interest, and another is strict scrutiny. So anytime our constitutional rights are limited, the government must prove, they have the burden to bear of proving a compelling government interest. For all intents and purposes, it's a really, really, really good reason. Right? It's not a matter of opinion. It's not a matter of choice or preference. This just has to happen. I know what the amendment says. I know what the rights are, but we just can't have this because society won't function. And even when proving that compelling interest, a really good reason, the impact of it must be strict in scrutiny, meaning that any sort of interpretation or any sort of law can only specifically apply to that one instance and can't spread to other rights. So for example, we go back to this decision, the District of Columbia versus Heller. The Supreme Court confirms that guns are a right that we get to have, and it's necessary now for the defense of the home. It's not necessarily based on being part of a militia. There is no question that any sort of government could try to make the argument of a compelling interest to stop mass shootings, school shootings, public shootings, whatever. There's a compelling interest. I think anybody in the United States would agree that we have a gun problem, but it's the stopping of it. It's the prohibiting of it. It's the prevention of it where we get into trouble, because the laws have to be narrowly tailored. They have to be very strict in their impact as to not bleed in. The one thing that this law did in Washington, D.C. was require the storing of guns to be disassembled, unloaded, and with a locking mechanism on the trigger. Supreme Court struck down the law, saying that it wasn't strict. It wasn't narrowly tailored. If the whole point of being able to keep and to bear arms was for defense, whether it's individual or home defense or against government tyranny, if the whole point of keeping a weapon was for some sort of defense, how could one be defending himself, herself, their home, if they first have to reassemble their gun, load the gun, and then remove the locking mechanism from the gun itself before it could actually be fired? They said that this was too broad. It had too much of an impact because we have a constitutional right to protect ourselves, to defend ourselves. There are laws that prevent people from having bombs. And I don't think anybody in this class would have an argument as to why people should be able to keep bombs. I mean, I don't get to build an explosive device in my garage and then tell the police officers or the FBI or the ATF that, well, this is for me to defend my home. I'm not just going to be defending my home. I'm going to be blowing up the neighborhood. It's a little too much. The government could say we have a compelling interest to prevent people from having explosive devices because we don't want chaos. We don't want casualties. We don't want unintended consequences. You can't have a bomb, but you are still able to follow, you are still able to defend your home by keeping a weapon, a gun, some sort of, let's go back to the language here, ordinary weapon. a lot of these gun laws, and you're going to see a little bit in the video here that you're going to watch the rest of the week. A lot of these gun laws that get brought up into attention by the National Rifles Associations, they're very broad. People aren't able to defend themselves because of these laws. Yes, they're trying to stop mass shootings, no question. But you still have to allow people to defend themselves. And if your compelling interest bleeds into other constitutional rights, we have an issue. All right. Video guide targeted. So this is a very pro-gun documentary, right? We had a pro-gun control documentary this week. Now we have a pro-gun rights documentary. Found a free streaming service for us. This is on Tubi TV. So this is a free documentary. It's about an hour long. So you should be able to open up the link there. And then obviously you're going to be answering the questions while you're watching. You should have this done by Tuesday next week. There is no video for tomorrow. There is no video for Friday because again, I'm not here. I have an early release and we have meetings in the afternoon. So if you need me between now and Friday, you're gonna have to drop me an email if you're not coming into that Zoom. So with that, you guys have a great rest of the week. Hopefully you enjoyed the snow and I'll see you guys next Tuesday. Go Spartans.